Good morning. Welcome to our webinar. My name's Damien Falkowski, and with Simon Edwards of 39 Essex Chambers, we'll be presenting this webinar, Freehold Covenants and Landlord's Intention, the Acid Test. What we're going to be talking about today, well, it's always a bit disturbing when what you've always understood to be settled law is turned on its head, but that is why we have the Supreme Court. Simon will be taking you through the decision of France Cavendish Hotel, and then I will be considering 89 Holland Park Management Ltd in Hicks, a case about lessees and freeholder successors in title of the vendor's land, ability to enforce a restrictive covenant under Section 78 of the Law of Property Act 1925, and whether or not one can take into account aesthetic or environmental grounds as relevant considerations when deciding whether to grant or refuse consent.
Thank you very much, Damien. And as you say, we're going to start off by looking at the Supreme Court's decision in Frances. But first, we've got a nice picture of Betty's Cafe, which is in Bradford. I loved that case as a law student because it was so easy to remember with a name so readily in my memory as Betty's Cafe. Also, it was nice and simple and something you could get hold of and understand, which as a law student was also a very important factor. Can we have the next slide, please, Damien? Now, what was Frances all about? It came to the Supreme Court on one simple issue, and that is whether when a landlord seeks to oppose the grant of a new tenancy for a business tenant who has protection under the Landlord and Tenant Act 1954, it can successfully oppose that application on the grounds that it intends to demolish or reconstruct the premises comprised in the holding and cannot reasonably do so without obtaining possession, if that intention would be absent. In other words, the landlord wouldn't intend to do that if the tenant left voluntarily rather than desiring to stay exercising his statutory rights. Next slide, please, Dave. Now, as we all thought the law to be, right from almost just a few years after the Act was passed in 1954, we all thought it was pretty straightforward and as set out in Betty's Cafes. That case, of course, concerned a slightly different situation, namely the landlord who wanted to reoccupy the building couldn't rely on the ground which you can oppose if you want to reoccupy, which is Section 31G, because of the condition, which is that you have to have held the reversion for at least 5 years, and the landlord hadn't. So instead, it said, well, in fact, I also want to carry out substantial works, and I can't carry out those works without gaining possession of the holding, thus I can rely on Section 31F. Next slide, please, Dave. Anyway, in the House of Lords, one of the major issues was the question which was settled, namely, when is the date at which the intention is to be assessed? And it was held that that was the date of the hearing, because in Betty's Cafes, the relevant intention had only been formed, well, if I recall rightly, during the hearing before Mr. Justice Dankworth's itself. And then it went on to hold the fact that the landlord was not in a position to use Section 31G was totally irrelevant. in Viscount Simon's speech, he approved a definition of intention, which again, clear as you like, something we could all learn at law school, and it's one of from Lord Justice Asquith in Cunliffe from Goodman. So can we have the next slide? We'll have a quick look. And it's beautiful in its simplicity. And intention, to my mind, connotes a state of affairs which a party intending does more than merely contemplate. It connotes a state of affairs which, on the contrary, he decides so far as in him lies to bring about, and which in point of possibility has a reasonable prospect of being able to bring about by his own act of volition. So something which, two-stage test, one subjective, one object. And from that day onwards, it was held to be axiomatic that landlord's motives completely irrelevant, except if you wanted to challenge whether the landlord's intentions, its protestation intention, was genuine. But there was usually a way around that anyway, and it was used in Betty's cafes and used many, many times since. Namely, the landlord would give an undertaking to do the work within a reasonable time of the termination of the tenancy, thus proving, if you like, the genuineness of his intention. Thank you, Damien. Now, what did Francis do? Well, we start off with going back a bit, and what were the facts of the Francis case? The landlord, in its evidence, was totally frank. It made it clear that the works had no commercial utility, none at all. In fact, they made life more difficult for the landlord and were designed solely to satisfy Section 31F, so that, and they said this quite frankly, if the tenant just left, the works wouldn't be carried out. His Honour Judge Sagerson, when the matter came to the County Court of Central London, accepted this as a genuine intention and backed up as it was by an undertaking, and held that the landlord's motive completely irrelevant. So following standard law that we learned for ages. Thanks, Damien. First appeal went to Mr. Justice J, and he upheld the first instance decision. It was challenged before him that the intention was actually genuine, but he, although with a little bit of hesitation, said yes, it was genuine, and held also, along with his Honour Judge Sagerson, that the fact that the work would not have been done had the tenant left voluntary completely irrelevant. In fact, he allowed the appeal on other grounds which would have required a further hearing in the County Court. Thank you, Damien. Now, we get to the Supreme Court. The appeal was leapfrogged to the Supreme Court, so we didn't have the Court of Appeal having a look at it. And Lord Sumption gave the leading judgment. Now, he accepted, because in a sense he had to, that motive was irrelevant, apart from establishing the genuine nature of the intention, but went on to say that wasn't the end of the matter, because the appeal turned out on what was the nature or quality of the intention that ground F requires. Now, actually, to be honest with you, I think that's a bit odd, because what ground F says is about the nature of the intention is pretty clear. It says the landlord intends to demolish or reconstruct the premises comprised in the holding. What elaboration is needed? You may be forgiven for thinking I'm not too keen on this judgment, but there you are. Next slide, please, Damien. Now, problem solved, paragraph 19. And he says, oh no, it's not. The problem isn't the mere conditionality of the landlord's intention, but the nature of the condition. Because what he says is, Section 31F assumes that the landlord's intention to demolish or reconstruct is being obstructed by the tenant's occupation. Hence the requirement that the landlord could not reasonably do so without obtaining possession of the holding. Well, yes. Then he goes on, after a little diversion to Section 31A, to say these provisions show that the landlord's intention to demolish or reconstruct must exist independently of the tenant's statutory right claim to a new tenancy, so that the landlord's intention, so that the tenant's right of occupation under a new lease would serve to obstruct it. And so the acid test is whether the landlord would intend to do the same works if the tenant left voluntarily. Next slide, please, Dave. So his reasoning, it appears to be Section 1F, Section 31F requires the tenant's occupation to obstruct the landlord's intention. But that's not what the subsection says. It says that he could not reasonably do so without obtaining possession of the holding. In other words, the landlord's obstructed as a matter of fact from carrying out the works, not that the landlord's intention is so obstructed. So what we got here is a little bit of judicial gymnastics to achieve a result, I feel, that they wanted to achieve on the merits. Lord Briggs gave a separate judgment, agreeing with Lord Sumption's reasoning. He did so mainly because of His Honour Judge Sankerson's concerns of the implications of having to explore a hypothetical situation of what the landlord would have done if the tenant left voluntarily, when ex hypothesis you're at a hearing where it's perfectly clear the tenant isn't going to leave voluntarily. Well, again, we get a bit of mental gymnastics here. Next slide, please. And he says, oh, there's nothing hypothetical about this. He says the disqualifying underlying purpose, just to get rid of the tenant, is a continuing aspect of the landlord's then current intention, even if the direct question whether in other circumstances the tenant going voluntarily, the landlord would have intended to do the relevant works, appears hypothetical. Oh, well, it's not hypothetical at all. No, no, no. No, it's all part of the necessary conditions for opposing on this ground. So a little bit more mental gymnastics. In fact, in the judgment, the Lord Briggs highlighted questions which you might ask a landlord, and the landlord might say, well, actually, I've never really thought about that. Why should I think about something which hasn't and will not ever happen? This is silly. Anyway, we carry on, Damien, please. He also then went to deal with another problem, which is whether the landlord would be defeated if its intention was to do lesser works if the tenant voluntarily, but he could be done without getting possession. And he agreed that, yes, that would also prevent the landlord resisting on this ground. And he accepts, however, that this will probably give rise to factual questions of some nicety, incapable of resolution by the proffer of a simple undertaking. This may introduce an element of complexity and expense into proceedings, which for many years have yielded to a simple technique, a simple, speedy resolution. Well, that may well be. Next slide, please, Dave. Well, where next? As you will have gathered, I'm not particularly impressed by the reasoning of the Supreme Court. It's mental gymnastics to achieve a result in a case which otherwise would have led to what they saw as a plain injustice. However, we have to adjust to this new reality, and therefore a tenant from now on can say that a landlord is only proposing to carry out works to get a possession order and wouldn't do them if the tenant left voluntarily, and that will have to be investigated. In fact, that case could have been put forward in the Betty's Cafes case, and no doubt in others since then, and who knows what that result would have been. So next slide, please. We've had a couple of cases reported since Frances. One was pretty straightforward, again in the County Court of Central London. The issue didn't, on my reading of the judgment, really arise. It did arise in a completely different context, though, in the EE and Chichester case, where the upper tribunal applied the reasoning to resistance to electronic communication code rights on the grounds of whether, on the grounds that the landowner intended to do works which would prevent the exercise of those rights. That was quite an unusual case in that the landowners were a group of trustees of a large land settlement. And the case did involve both the issue of whether the intention to do the works was genuine and whether it was conditional on the electronic communications company asserting its code rights. Next slide, please. The result was that the landowner lost, and rather unusually, not only did the tribunal hold that the intention to carry out the works was conditional, but also that it wasn't genuine, which is a strong thing to say in relation to a board of trustees of a large landed trust. But there it is. And so it was applied. By the looks of it, the ground covered was the sort of ground that you would cover in attacking the genuineness of the works. But obviously that ground wouldn't ordinarily be covered, wouldn't have been covered up to now, because the landlord would simply have given an undertaking, and that usually would have covered the matter. Next slide, please. Now, this will obviously present tenants with a new avenue to explore when defending against opposition on Section 31F grounds. And landlords, on the other hand, are going to have to make sure that when they're deliberating about a proposed scheme, there's nothing in their deliberations, which if it's a limited company will all be in board minutes and so on and so forth, and emails and so on, that suggests that the true ulterior motive is to get rid of the tenant. Not suggesting that ever a landlord would hide such an ulterior motive, heaven forbid, but they will certainly have to be careful that it's not somehow suggested. And there'll be more disclosure sought and closer scrutiny of a landlord's motives for the first time for some 70 years. And undertakings, they may no longer be enough to satisfy the court's requirements, and one can readily see that as a result, more cases will be contested and more expense as a result. But I suppose one might say it all makes work for the working man to do. Can we have the next slide, please, Dave? And then, what about Section 31G? That gives the landlord a reason for opposing a tenancy, that on the termination of the current tenancy, the landlord intends to occupy the holding for the purposes of a business to be carried on by him therein or as his residence. Well, can the Frances reasoning, namely that the intention must be free of any taint or condition, that it is only formed in order to get rid of the tenant, can that reasoning be applied to this subsection? Well, there's a difference in that there is nothing in that subsection which says specifically and that the landlord could not occupy the holding without obtaining possession from the tenant. It doesn't say that specifically, but it's clearly implied, because how could the landlord occupy the holding as well as the tenant? Can't have joint occupation between the landlord and the tenant, because the tenant has to have exclusive occupation. So it's clearly implied. So next slide, please, Dave. So we look at the ending, the final words of Lord Briggs, paragraph 32 of his judgment. It seems to me always to have been the plain intention, well, just for the last 70 years didn't spot it, of Parliament, that a tenant's statutory right to a new tenancy should not be circumvented by proposed works which, viewed as a whole, would not have been undertaken by the landlord if the tenant had left voluntarily. Well, why not? Why you might think, was it not also Parliament's plain intention that a tenant's statutory right to a new tenancy should not be circumvented by proposed occupation which would not have been proposed by the landlord if the tenant had left voluntarily? In other words, if the tenant had left voluntarily, the landlord wouldn't have occupied, but now he intends to, just to get rid of the tenant. Could it not be said, therefore, that Parliament could not have intended that, and that therefore Frances applies equally to section 31G? Well, on that, we shall have to wait and see. And thank you very much, Damien. Over to you.
Thank you, Simon. And before I start on freehold covenants, just to remind you that we have a question and answer facility. So at the end of my presentation, perhaps you'll have some questions for us. 89 Holland Park Management Ltd and Hicks. This concerned freehold restrictive covenants. Question of consent not be unreasonably withheld. Can consent be reasonably refused on aesthetic or environmental grounds? And what happens if the covenantee gives good reasons and bad reasons? Do bad reasons infect the good reason? So this is 89 Holland Park. This is a land where, according to the popular press that were reporting this case, A-list celebrities. Celebrity residents include Beckham's Elton John and Robbie Williams. So 89 Holland Park, large detached Victorian building, and it's at the end of a row, divided into 5 flats, all held on long leases, 4 of 999 years and 1 of 125 years. Freehold owned by 89 Holland Park Management Limited, and each of the flat owners, as is common in these situations, is also a shareholder in the management company. So the company retained possession of the common parts and external structure of the building, but otherwise
hello again. It looks like we've lost Damien, and he was going through the slides. I'm afraid I can't advance the slide because he's presenting them, but I do have the slides on a separate screen, so I can walk you through them. He was talking about the scheme at 89 Holland Park, and many of you will know the background facts, but basically the owner wanted to build a futuristic underground house in West London, but her neighbours objected to the scheme on aesthetic grounds. The development involved, as developments commonly do in central London, a double basement, and the plans were pretty extensive. The architect was a celebrity architect and wanted to build a modern glass-fronted house in Millionaires Row, she got planning permission from the council, but 7 wealthy neighbours, we already heard about a few of them, objected to the new development. The plans involved a single-storey glazed building, described as a glazed cube structure, with 2 floors below street level. So we come to the history of the matter, and basically the estate was laid out in the mid-19th century, the early 19th century, and there were covenants binding the land, and the covenants all governed by the doctrine of Talcum Moxey, with which we're all thoroughly familiar, and namely that if a covenant touches and concerns the land, it is the benefit of the covenant is annexed to the land, and the benefited land sufficiently identifiable. Successors entitled can enforce the covenant so long as it's A, registered on the title of the burdened land, and B, negative in nature. The issue, the covenant in question, was that the building owner shall make no applications to the planning authority, nor provide nor apply for any other necessary provisions in respect of plans which have not been approved by the adjoining owner, provided that if the adjoining owner shall approve the same, the building shall be required to modify or amend the same by the planning authority. So there was a covenant against making alterations to the building, save with the approval of the adjoining owners. And ordinarily, of course, and in this case, it's such a clause is subject to an implied term that such approval should not be withheld, save on reasonable grounds. And that's was established a good long time ago, and it is well-established law. So the position with which the owner of the property was faced was that they wanted to carry out these modifications, these create this really rather unusual for the area property. Holland Park itself is full of very, very grand houses built largely in the 19th century, some earlier, some later, but very grand. And this was unusual, but notwithstanding that, notwithstanding the heritage status of the area, the local planning authority, Kensington and Chelsea, had indeed, they had got planning permission, and that was granted eventually, actually on appeal, for what they wanted. It's worth actually having a quick squint at what the planning inspector said. He described the entrance of the building as being more noticeable at night as a gently glowing glass box. Somewhat unusual nature, but he held in the end that that was a good scheme, and he got Hicks got consent. But the company refused consent, saying our decision is to refuse consent for aesthetic reasons and the loss of the amenity of the trees. But in any event, we must withhold consent unless and until you satisfy serious concern raised by Capita. And Capita were engineering and hydraulic experts. And those of you who do any sort of planning law will know that one almost inevitable objection to any basement work is, oh, it's engineering the impossible without destroying neighbouring properties, and it will cause flooding. That is absolutely common parlance. Now, in any event, the matter first came to court in 2013, as long ago as 2013, and it's reported in 2013 EWCA 391 Chancery, but you'll get the slides so you can get the references. And what happened was Sophie Hicks and the neighbours battled it out. A number of issues were before the deputy judge at first instance, and it was held that the restrictive covenants were enforceable both by the freeholding company and also by leaseholders, because they had the benefit of the covenants by virtue of Section 78 of the Law of Property Act. And he then he decided that Miss Hicks was bound by the covenant, so burden and benefit have passed. And he also decided that it was necessary to imply a proviso to the effect that consent was not to be unreasonably withheld. So that's, if you like, the groundwork that the judge had to go through to carry on with the matter. And it seems that we might have Damien back. And Damien, I've skipped through to slide 36.
Right.
If you want to take over now, which I think is probably getting to the meat of things. Slide 36.
Yes.
So over to you.
Thank you very much, Simon, and apologies there for my lack of internet connection. So I think Simon's just covered with you the first issue arose whether consent could be unreasonably held, whether a term was to be implied. So then the judge looks at the 1965-1968 deed, and looking at the background, and he's applying the usual tests that we look at when construing the relevant circumstances and so forth. I accept the claimant's submission that Brigadier Radford's only interest in the building at the time when the 1968 deed was entered into was in preserving the structure, capital value, and revenue generating capacity of his property. So the judge is very much focusing on, this is really just about an income stream. The flats are all occupied and bringing in a rental income. So he doesn't really consider that there's very much more to it than that. It's a question really just of valuation and income stream. And then he looks at the established authorities, consider general purpose of covenants. Generally, the sole purpose of a covenant requiring approval by a covenantee is to protect the property interest of the covenantee, Iqbal and Thakra. If what's proposed has no impact on the covenantee's property interest, then it is generally not entitled to refuse consent. There's nothing either in the language or the documentary, factual or commercial context of this case that suggests that the parties to the 1965 transfer and the 68 deed had any intention other than to protect Brigadier Radford's property interest in the building. So having decided that these covenants are concerned exclusively with just protecting the property interest, he then comes on to consider Miss Hicks' application for consent and only focusing on the freehold reversion. So having come to that conclusion that this is only about freehold reversion and valuation and common parts and external structure of the building, he says that it was not entitled, the land was not entitled to, sorry, the covenantee was not entitled to refuse approval based on aesthetics, disruption caused by construction, or risk of damage to or destruction of trees, other than to the extent that the risk of such damage or destruction might adversely affect the structure of the building or the value of the reversion. So we arrive at a conclusion where he reaches no decision on the aesthetics, because he says that's not a relevant consideration. And he is of the view that the engineering issues are not sufficient to entitle the covenantee to refuse consent. So he held that concerns that had been raised were insufficient to justify refusal or consent under clause 2b, but were potentially good grounds for refusal of consent under clause 3. And clause 3 is a requirement to give full details before commencing any works. So he granted a declaration that consent under clause 2b had been unreasonably withheld. That's because the covenantee was, in his view, confusing the requirement to provide details about what one was going to do rather than the point on consent. So the Court of Appeal disagrees and says that the judge was wrong in considering that one could only take into account matters that affected the reversionary interest, and they consider that the interest of the leaseholders, whether or not their property interests, were relevant. And so they say that the proper approach is identify the land for which the covenant was given, then consider what the general purpose of those covenants is, and they were to control the development of the property, not just for a value of a reversion as an investment, but also for the leaseholders, because they are among the class of people who benefits from the covenant. And they are supported in their view by Section 78 of the Law of Property Act 1925, which, as we all know, effectively writes words into the covenant. And by, it's a conveyancing shorthand. By Section 78, a covenant is deemed to be made with the covenantee and his successors in title and the persons deriving title under him. Furthermore, the covenant has effect as if those words were written out. So successors in title will include owners and occupiers for the time being of the land. So they took the view that if you add together the general purpose of the covenants and the class of persons entitled to the benefit, one reaches the conclusion that it has to include not just the freehold reversion company, but also those people who are living there, enjoying it under their long leases, and were it otherwise, then the purpose of that covenant would have been undermined. So they then come on to aesthetics. They consider that one has a legitimate reason and expectation in such a covenant that one should have some degree of control. So what we had here was a case of some good reasons and some bad reasons. Looking to the case of West India Quay and East Tower Apartments, if you have it's established that you have a mix of reasons, some good, some bad, then the question is, do your bad reasons vitiate or infect your good reasons? Now, in this case, the trial judge had been wrong to rule out aesthetic and environmental considerations. Those were relevant, but he was right in his conclusion that the construction issues were relevant to clause 3 rather than clause 2b. So the covenantee there had some good and some bad reasons. The result remitted to the Chancery Division for the judge to consider whether the aesthetic and environmental reasons were reasonable ones. And balancing up the good and the bad reasons, the Court of Appeal considered that really the aesthetic reasons were the most important reasons of the decision, and it could therefore fairly be said that had the construction issues not been in play at all, then consent would still have been refused on aesthetic grounds. I'm going to see now if we have any questions. I can't see any coming up on the screen there.
Damien, I can see one for you. Yeah, it's come up on my screen, it's a question really about the crossover between restrictive covenants and planning law, because we saw here that permission was granted on appeal for this development, indeed eventually and remitted. We don't know what the result will be when it goes back to the first instance judge, but the question is that what is the crossover between planning law and restrictive covenants, particularly in view of the right for people to apply for the discharge of restrictive covenants? That's the question that I hope I've summarised correctly.
Well, there are a number of very interesting points there. We've seen in the Taylor and Coventry case how important planning permission can be, for example, in the context of nuisance. Also, if we're considering the situation of aesthetics, then I can see it being a powerful consideration if a local planning authority, particularly, for example, if it's a conservation area, if a local planning authority has taken the view that planning permission should be granted, then it will have taken aesthetic considerations into account. But that, I think, only gets you so far, because you really have to concentrate on the wording of the covenant. And you really have to ask yourself on what grounds could consent be reasonably refused if it's aesthetic. And it may not be sufficient just to say, well, the local authority, local planning authority takes the view that it should be allowed, because that may not be really what the thrust of the covenant in its context really requires. You've now got the third limb that our questioner very perceptively, if I may say so, raises, which is, how does Section 84 come into the mix? Well, as we know, this enables not only leasehold covenants, but freehold covenants as well, to be modified or discharged, where it will otherwise lead to an interference with reasonable use of the land. So I think planning is extremely relevant consideration in it. And thank you very much for that very perceptive question.
And there's another one just come in for you, Damien. I'll read this out. It's we have a case where neighbours have restrictive covenants limiting development to a subsidiary development, a gardener's cottage. We think this is unreasonable, and a separate dwelling should be okay, provided it's aesthetically okay. Do you have a comment about that? I'll read it again. The restrictive covenant limits development to a subsidiary development, and the owner, the burdened owner, wants to build a separate and therefore not subsidiary dwelling.
I will be very happy to take this question outside the live webinar, because I'm not sure that I fully understand how this arises. Maybe it's because it's being read to me rather than because I'm looking at it, unless you have an immediate view on it, Simon.
Well, I think my immediate view, not being able to see the restrictive covenant itself, but if it says, if it's absolute, in other words, it's unqualified, and that is very important, as we've seen in the Hicks case. If it's unqualified and the restrictive covenant satisfies the benefit and burden, etc., etc., if it's unqualified, then it may well be sufficient under the law of covenants to prevent a development which creates a separate dwelling. But Section 84, as you say, Damien, might come to the burdened lands assistance, particularly where we're in a social situation where new homes are at such a premium.
Thank you, Simon.
Unless there are any other questions, I'd just like to end up by saying thank you to everybody who's attended. We'll send out an email to everybody with the slides, and so you'll be able to catch up on those slides that you didn't see from Damien's presentation. We also run a series of webinars on property construction and planning issues, and update on COVID-19 issues. And at this stage, ordinarily, I'd be saying to you, well, now you can go into the room next door and we'll all have a glass of wine and a packet of crisps, although we actually usually do better than just crisps. Unfortunately, at the moment, we can't do that. Thank you very much for coming, and I hope that sooner rather than later, we'll be able to see you in person at 39 Essex Chambers after a webinar with a glass of wine. Thank you.
And thank you, Simon, for taking over as my broadband had insufficient width.